and his affidavit at page 2673. Then there is again the SCA minority judgment at page 2632, paragraphs 128 to 202, and Mr. Makate's heads of argument, paragraphs 85 to 111 and 131 to 158. Would you add to that list the misleading statements in their heads of argument identified in our heads in reply? It's our heads in reply, page 24, paragraph 50. And it would, with respect, not serve any useful purpose for me to try to recite all of the competing evidence, because that is simply not a fruitful exercise and one that should be embarked upon. May I also say, with deference and respect to my learned friends, their heads of argument frequently make statements of fact of the record which are not correct, and that we would urge you not to take their assertions of what the record shows at face value. And let me give you two examples. Firstly, in their heads of argument, paragraph 28, our learned friends say, Vodacom's real complaint is that the majority of the SCA, and then they purport to quote our document, is that the majority of the SCA, quote, erred in evaluation of the evidence and determination of the issues before it. They say in footnote 29, that is a quotation from our application for leave to appeal, volume 25, page 2566, paragraph 8. But if one goes to that paragraph on which they rely, that's page 2566, paragraph 8. This is our application for leave to appeal. Then you see in paragraph 8 that what we really said was this. Vodacom does not say that the majority judgment is unconstitutional merely because it erred in its evaluation of the evidence and determination of the issues before it. Its orders are unconstitutional because they fell beyond the jurisdiction and were the product of the majority's ignorance or disregard of the issues in the case and the evidence before them. So the paragraph they cite, and from which they purport to quote, actually says the opposite from what they contend it says, by way of quotation from the paragraph itself. And then there is another example in Mr. Makate's heads of argument, page 22, paragraph 68.2. They say, secondly, the SCA majority found that the judgment of Hughes J was correct, that, quote, the CEO's determination was not reasonable, unquote. The majority of the SCA endorsed the factual findings made and legal conclusions drawn by Hughes on the full conspectus of the evidence. Just listen to this, what they attribute to that paragraph. The majority of the SCA endorsed the factual findings made and legal conclusions drawn by Hughes J on the full conspectus of the evidence. If you go to their reference, their footnote 76, they refer to the SCA majority judgment at page 2600, paragraph 21. And what the court said there, the SCA majority, in paragraph 22, I accept that the High Court was correct, as conceded by counsel for Vodacom, that the CEO's determination was not reasonable. That was the sentence on which they based that finding, that the court endorsed all the factual findings and all the legal conclusions in the full spectrum of all the evidence and the law. In fact, it's a statement by the Supreme Court based on a concession they say I made, which they know I didn't make. So to characterize that as an endorsement of all the findings by the High Court is wrong. May I turn lastly to the issue of the determination of incremental revenue. This is an issue addressed in our heads of argument from page 38 in paragraphs 128 to 144. The starting point, the point of the exercise is to determine to the extent to which the PCM product increased Vodacom's income. That was the purpose of the exercise. But that was a very complex exercise for a variety of reasons. The first question that arises is what they could identify is when a PCM message was sent, and then they could determine whether the recipient of the PCM message phoned back, whether within an hour or a day or a month. And they then said to themselves, how do we determine whether it was the PCM message that prompted the return call rather than a return call that would have been made in any event? Mr. Makate then suggested, on the basis of their calculations, Mr. Makate suggested that they assume that 24% of all those return calls were triggered by the PCM. And the CEO accepted that suggestion. So the first hurdle was overcome on the basis proposed by Mr. Makate. But it doesn't take one home, because all it says is that we now know, in response to a PCM, which of the calls were triggered by the PCM. What we don't know is firstly whether that call would have been made anyway, even if the PCM hadn't been sent. And the CEO mentioned an example. He says, for instance, a mother has to fetch her daughter from school after sports, but the mother doesn't know when the sports meeting will end, and the daughter then sends a PCM message when she is ready to be called. But there would have been a call anyway, even if it hadn't been for PCM. So you cannot say that that call triggered by the PCM is an additional call. It's a call that would in any event have taken place. So you can't tell whether the 25% are calls that would not have been made otherwise. But there's a further complication, and that's this: that even if the call is incremental, you don't know whether the revenue earned from the call is incremental. And let me explain that with reference to two examples. Firstly, a pay-as-you-go subscriber who buys 100 minutes of airtime every month. And the subscriber then carefully budgets to make sure that she only spends 100 minutes worth of airtime every month. Assume for the moment that that subscriber is now induced to make 20 minutes of calls she would not otherwise have made by PCM. In other words, she is one of the 24% induced by PCM to make a return call. But our conscientious subscriber still makes an effort to keep within her budget of 100 rands a month. She, in other words, forfeits some of her other calls, social calls, that she would otherwise have made to accommodate the PCM-induced calls. So Vodacom does not make any incremental income from that subscriber, despite the fact that it's a subscriber who responded to a PCM by making a call she would not otherwise have made. Because she keeps within her budget, Vodacom still just makes 100 rands a month from her. There's another subscriber, one who is a contract subscriber. And she's important because she's one addressed by Professor Weiner in an opinion on which Mr. Makate relies. It's a subscriber who has a contract. The contract allows her 80 minutes of talk time per month. She normally only uses, it allows her 100 minutes of talk time per month. She normally only uses 80 minutes of talk time. What PCM does is to persuade her to make more calls so that she uses the remaining 20 minutes. So she moves up from 80 minutes per month to 100 minutes per month. But she still only pays Vodacom 100 rands a month. So she does not, Vodacom does not make any incremental income from her calls. And the CEO was troubled by this feature because he said, all we have determined is the number of calls triggered by the PCM, but we haven't determined the incremental revenue that Vodacom would earn from those calls. And said the CEO, if you look at Vodacom's revenue overall, total voice revenue, in the period after the introduction of PCM, there is no income detectable of voice revenue per subscriber. They say our revenue increased because our subscriber base increased. But if you look at the revenue per subscriber, there was no discernible income, rise in the income over those 5 years, which would have happened if PCM had such a dramatic impact as Mr. Makate suggested. So the CEO discussed this issue with Mr. Makate's counsel at length as to what to do. How do we determine whether there was any incremental income, and if so, how much? And Mr. Makate's counsel could not suggest a way of solving that problem. He suggested that you must do the best you can, as our courts often do when they quantify claims for damages. What the CEO then did was to say that this overall profile of Vodacom's income suggests that there might be no incremental income. But I'll give Mr. Makate the benefit of an assumption that I make in his favor, which is a robust assumption, that 24% of those calls returned in the first hour are incremental, and therefore that the income earned from them is incremental income earned by PCM. So he assumed it was a best guess and no more, but he assumed in Mr. Makate's favor that 30% of those calls rendered incremental income. Now, of course, they criticize it because they say there is no evidential foundation for it. That is so. But that is the CEO doing the best he can and making an assumption in Mr. Makate's favor. If he had to confine himself to hard evidence, there would have been no evidence of any increase at all. So it's an assumption made in Mr. Makate's favor. What Mr. Makate then did was to file an affidavit by Professor Weiner. Professor Weiner is a professor of accounting, and it must be borne in mind that his affidavit speaks only of accounting and nothing else. And the part of his affidavit on which they rely is relevant only to our last example of the contract subscriber who normally uses only 80 minutes of her 100 minutes and is now induced to use the full 100 minutes. That is the one that he addresses. And I want to emphasize that Professor Wayner's affidavit has nothing to do with the other examples. This is the only one on which he weighs in on incremental income. And he does so by telling us that there is a rule of accounting that says that when a company receives revenue, which it still has to earn by delivering a service to the customer, then as a matter of accounting, the revenue may not be recognized as income. It must be put into a suspense account. And then as and when the income is earned by calls made by the subscriber, the company may transfer the revenue from the suspense account into income. So says Professor Wayner's accounting evidence. As a matter of accounting, in the before PCM scenario, you would only have been able to recognize 80 rands of the subscriber's monthly dues at the month end, whereas PCM now allows you to recognize 100 rands because that is what is actually used in the month. That is where Mr. Makate stops. So says Mr. Makate, Professor Wayner proves you now earn incremental income. But that's because they read only half of what Mr. Wayner says. Mr. Wayner, in fairness to him, doesn't stop there. He deals with what happens to the 20 rands, which is not taken to income at the end of the month. And he deals so in his affidavit by telling us that that unused airtime then prescribes, whether at that month end or a month later or 3 months later. But it prescribes that it is forfeited. And when it does, the 20 rands may be taken from suspense account into revenue. So that, and that Mr. Wayner makes clear in his affidavit. If I may just give you the references where he deals with that issue. Page 1340, paragraph 6.3, where he says that the allocated minutes credited to the user will ultimately expire, i.e. are forfeited to by the customer without a refund. At page 1346, paragraph 17.4, he says that the income can be taken from suspense to income only when it's earned or, quote, until the carry-forward airtime expires. And lastly, at page 1348, paragraph 22, he says, however, in relation to expired or forfeited airtime, revenue is recognized when the actual expiry date is reached. And I skip a sentence. The liability is only reduced or eliminated by the utilization of airtime by the customer. And then I emphasize, or the ultimate expiry of the time by which the airtime had to be used to the extent of unused airtime at that time. So, Professor Wayner's accounting. Certainly, I'll try to fill them. Professor Wayner's accounting is, as always, excellent, but is utterly irrelevant to this case because the tail end that is ignored by Mr. Makate is even that airtime that was previously unused and is now used would previously also have gone to income when the credit expired. So Professor Wayner's affidavit, whilst good accounting, is a red herring. It has absolutely nothing to do with the determination of incremental income before you. Thank you, Chief Justice. Sorry, I'm told I made a mistake. I spoke of 24%. 27% was assumed to be, yeah.
So, Chief Justice, I don't know if other colleagues had questions.
Thank you, Mr. Trenkov.
Thank you.
Mr. Trenkov, I'm here. Mr. Trenkov, I'd like us to go back to right at the beginning, the gateway of this court's jurisdiction. You've heard Mr. Makate's response to the contention that we have jurisdiction. He says that the issues that you raise about the judgment of the SCA, the majority, that is substituted the order of the High Court, you can't really rely on that because initially he sought substitution and Vodacom itself, when it appealed before the SCA, its contention was that the decision of the High Court, in fact, amounts to a substitution. What is your response to that?
It is true that the High Court's decision amounted to substitution in the admin law sense. They didn't merely refer the decision back to the CEO, they referred it back to the CEO with directions about the computation of the compensation. To that extent, it is correct. But the question is not what happened in the High Court, the question is what happened in the SCA. And only Vodacom appealed against that judgment. And it appealed against that judgment not only on the basis that the terms of the referral back were incorrect, it fundamentally appealed against that judgment on the basis that the CEO's determination should not have been overturned at all, or if referred back, that it should have been referred back on different terms. Mr. Makate did not appeal, and so that in those circumstances, the question before the Supreme Court of Appeal was whether Vodacom was correct in saying that the determination should not have been overturned at all, or not, and if it was correctly overturned, the terms on which the matter is referred back to the CEO. The question whether the High Court's order should be set aside and replaced by a completely different order which yields billions of rands more of compensation, that wasn't before the SCA at all. Not only was it not technically before the SCA, it wasn't technically before the SCA because Mr. Makate didn't cross-appeal. He didn't, in other words, raise any dispute with the High Court order. But he also didn't ask for it, and we weren't called upon to address the question whether that was a competent and appropriate order. So we submit with respect that the matter fell beyond the jurisdiction of the SCA, firstly because there was no cross-appeal, and secondly because, flowing from the first, because there was no Audi. The issue was not before the court.
Normally in appeals, if one is not happy with an order of the other court or lower court, you appeal or cross-appeal. Now, if there's no cross-appeal and the court is of the view that maybe it wants to temper with a judgment in favor of the other party, what should the court have done under these circumstances?
But the point is that the court doesn't have the power. Once it determines that the CEO's determination was correctly overturned and that it was referred back to him, it simply doesn't have the power to make a redetermination which was not sought for by anybody. You say, what should it do if it wants to make such a determination? It doesn't have the power to make such a determination if there is no cross-appeal. And that is simply because a court of appeal doesn't have a free hand in its determination of the appeal. It is confined to the appeal before it, which is Vodacom's appeal, which says the CEO's determination should not have been overturned at all, or if referred back, should have been referred back on terms different from those prescribed by the High Court. Nobody contended for the orders that the court made.
I hear you on the PowerPoint. Could it give notice to the other party? In these papers, Mr. Makate says, in fact, the SEA asked the parties whether, if it finds that the High Court erred, whether it could substitute the order.
I saw it say so, and I won't quibble with my learned friends. My memory is not good, but I have no recollection whatsoever of such a suggestion. I don't know whether it was put to me or to them or to both of us. But one thing I can say with absolute certainty is that there might have been a question put which says, may we change the terms on which there is a referral back. But what was certainly never put to me, and I submit to anybody else, was may we make an order in the terms sought in Mr. Makate's notice of motion. That would have been a startling proposition, and I wouldn't have forgotten something like that, and that was certainly never put to me or to anybody else.
The complaint about the majority having ignored the evidence on the issues, wouldn't that basically be similar to the court having failed to assess the evidence, in which case we would have to grapple with the factual disputes, something this court would not ordinarily do?
No, with respect, there's no dispute about our complaint at all. Our criticisms of the SCA are there for all to see. It does not depend on the evidence at all. It depends on one need merely look at the majority judgment to recognize those errors. And I don't understand our learned friends to contend that the court did not make those errors. I understand them to contend all sorts of other things. But even if such a contention were to be made, it wouldn't be the subject of a dispute of fact, because we don't rely on any evidence to demonstrate that the court is right or wrong. What we say is, look at the judgment. It doesn't recognize the issues. It doesn't recognize the evidence. It doesn't decide the issues. Now, those complaints are evident from the majority judgment itself, and they are not something about which there can be a dispute of fact.
My last point for now is on remedy. If we are with you, you say that the application, that is the review that was launched by Mr. Makate, should be dismissed. Alternatively, the matter should be referred to the SCA. I want to know, why would you seek a dismissal where you say the evidence has not been, it has been ignored by the SCA? In other words, nothing has been done.
Yes.
Why would we grant you the dismissal of the review application under those circumstances?
I understand, Justice Mtlantla. Thank you for the question. That is because my client's fundamental complaint is that it has not had a lawful hearing of its appeal. So it asks in the first place that this court overturn the SCA judgment and afford it the hearing which it has never had. So, and that is why we asked this court to inquire into the merits of the appeal. Both of us address the quantification of compensation and the attack on the CEO. So we asked this court in the first place to give us the hearing on the merits that we've never had. We understand that the determination of the merits is not a constitutional issue. It is incidental to and follows from the constitutional complaint that we have, that we've never had a hearing. So we would imagine that this court may respond to it in two possible ways. This court can either give us the hearing which we have sought and to which we are entitled, and that would be our preferred option, just because we and Mr. Makate are both tired of litigation. But if this court is not inclined to determine the merits of the appeal, well, then the other way of doing it would be to refer it back to the SCA for a different panel to determine the merits. But one way or the other, my client is entitled to a fair hearing on the merits of the appeal.
Thank you, CJ. Thank you, Mr. Trent.
Okay, can we start with Rand Refinery? Is it not distinguishable from this case? My reading and my recollection of Rand Refinery, the court was under the impression that there were no opposing papers. So it was not a matter of judges sitting and deciding what to include in a judgment when they look at the papers and when they look at the written submissions, which is what happens. You know, you get a record this big, and then when you're writing a judgment, you include some, you exclude some. And I'm not defending the majority judgment, but I'm just trying to map out what I see as the difference between Rand Refinery and this case.
Justice Chiki, sorry, did I interrupt you?
Yeah, no. You may respond, Mr. Trent.
Justice Chiki, you're quite correct. There is that difference. In that case, the court was unaware of an affidavit that had been filed, and that was why it was held. That was a failure of a fair hearing, because the court did not have regard to evidence that should have been before it. But the underlying principle is the same, and that is that a court should decide a case by recognizing and looking at and taking into account the evidence before it. And there is no indication in the majority judgment at all that the court was aware of the evidence before it. We don't know whether the court wasn't aware or whether the court was aware but simply ignored it. But one way or the other, that is an even more fundamental failure of justice when the court fails to recognize that there are issues before it, that there is evidence relevant to those issues, and that its function is to assess the evidence and determine the issues. So yes, you're quite right. There is a difference between the two, but the underlying principle we submit is the same.
Could it be said that perhaps the court did not produce that evidence in its judgment because it did not think that that kind of evidence was necessary for it to produce it in the judgment? I'm asking this, Mr. Trengrove. Let's move forward.
Justice Chiki, you are as perplexed as we are.
Yes, but then as courts, if we say each time, on each occasion, there's a certain submission which a certain party thinks was very important, and we say that and we accept that, just because that submission is not in the judgment, then we are clothed with jurisdiction.
Yeah.
That is my worry.
Yeah.
That if we accept your invitation, then it would mean that for us to be clothed with jurisdiction, we would have to nitpick a judgment, and parties would have to nitpick a judgment and look at issues that they raise or arguments they raise, and if those are absent in a judgment, persuade us that, in fact, we have jurisdiction.
Justice Chiki, again, you're absolutely right, and as you know, there is much learning on precisely that proposition, that the mere fact that something was not articulated in a judgment doesn't mean that the court did not take it into account. And for that reason, one takes a realistic approach in the assessment of any judgment. I accept that entirely. But this is not such a case. The court did not recognize the issues before it. The court did not recognize the evidence before it. The court did not apply any of the evidence to any of the issues. We're not complaining about a court's failure to take this into account or that into account. What we're saying is that there was a fundamental failure of the judicial process because the court didn't observe the fundamentals of decision-making by recognizing the issues, recognizing the evidence, and determining the issues on the basis of the evidence. So I submit with respect that it is fundamentally different, and I would also suggest that your judgment would obviously make it plain that this is not a case in which a court is criticized for not mentioning a piece of evidence or an issue in its judgment. This is not a case in which a court is criticized for overlooking a little bit here or a little bit there. The SCA majority failed altogether to identify the issues, to identify the evidence, and to determine the issues.
My next question is whether Section 34, the purpose thereof, is not really focused on the procedure, whether a person has had a right to a fair hearing. And if you've had a right to a fair hearing and a judgment is imperfect, can you then rely on Section 34?
Well, Section 34 entitles one to a fair hearing, which this court has held is fundamental to the rule of law. And a fair hearing would include a fair determination of the issues before the court on the basis of the evidence before the court and the submissions of the parties. In this case, the court disregarded the issues, disregarded the evidence, disregarded the submissions, and didn't even determine the issues. So we submit that it was a fundamentally unfair hearing because the court did not determine the issues on the evidence before it.
Mr. Trengrove, you do know that in this court, I'm assuming you do know, because of your, take this as a compliment. You are aware that this court is inundated with applications for leave to appeal. I'm thinking that if we start entertaining purely factual, private, contractual matters, we will not be alive to what the Constitution tells us to be the jurisdiction of this court.
No, that's quite correct. And this court has made it absolutely clear that a mere dispute of fact does not engage the jurisdiction of this court. And even a constitutional issue, well, even a dispute of fact under constitutional garb also does not trigger the...
Even a misapplication of the law.
Yes, indeed. But we submit with respect that it is fundamentally different when a litigant complains that I did not have a fair hearing. In fact, I did not have a hearing at all before the Supreme Court of Appeal. Because a hearing, performance of the judicial function under Section 34 does require an identification of the issues, identification of the evidence, and application of the evidence to the issues. Now, if a court performs that function, then the mere fact that it might make mistakes in doing so is not a constitutional issue, and this court will not afford leave to appeal. But when the court fundamentally fails to perform that very basic judicial function at all, then we submit with respect that that is a constitutional issue. That's a breach of the rule of law, because the court did not even perform the judicial function substantively as opposed to perhaps formally.
Well, in this case, what you are saying, because in your submissions you compared the majority judgment and the minority judgment. And what I'm understanding to be a complaint is not that you did not get a fair hearing. You are simply saying, even when you compare the majority judgment and the minority judgment, there are certain issues that were taken into account by the minority judgment, meaning that you did get an opportunity and you did get a hearing from the court, and it was fair. But you are saying that the majority, as compared to the minority, did not deal with those matters. And this is where I struggle to find the whole issue around fair hearing. And then think that perhaps one then would be tempted to look at a judgment and look at what is in the judgment, because as you say, we don't know if the majority, some of these issues that you've referred us to, I think there are about 8 of them, occupied the minds of the majority or not. But it's just that they are, as you say, not very clear on the judgment.
No, with respect, our complaint is not that they were not very clear. They were absolutely clear. And what is absolutely clear is that they didn't identify the issues, didn't identify the evidence, made a long list of incomprehensible statements about the issues and the evidence which were simply inexplicable. So that our complaint is that they didn't consider the issues, the evidence, and didn't decide the issues. Now we invoke the comparison of the minority judgment, for which we are grateful, because it illustrates what a proper exercise of a judicial function would look like in a case such as this. But we don't suggest that the majority is wrong because they differed from the minority. Our complaints would have been exactly the same, even if it had been a unanimous judgment. It's got nothing to do with a comparison between the two. We merely suggest, we illustrate our point, that the minority did what judges should do, identified the issues, identified the evidence, and determined the issues on the basis of the evidence. We appeal against, or we would have appealed against, one of its findings against us, where we submit that it is wrong. But that is a conventional complaint by a litigant about an error in a judgment. That is not a constitutional issue. So the comparison with the minority is invoked simply to illustrate our point. But our appeal would have been exactly the same even if there was no minority judgment.
Well,
and it has nothing to do,
yes.
It has nothing to do with any dispute of fact on the papers. Nothing whatsoever.
Well, I did say I'm not at all defending the majority judgment of the Supreme Court of Appeal.
No, I understand that, Justice.
But what my concerns are whether that in itself clothes the applicant or this court with the jurisdiction.
Yes. Thank you, Justice Chiki.
Mr. Tingrove, I also have some concerns about jurisdiction. If I understand what the applicants are saying, that...
Sorry, Justice John, I'm finding it hard to hear you.
Please. So I also have some concerns about jurisdiction. If I understand the case made out by the applicant for jurisdiction it's relying only on Section 34, read with Section 1C. If the errors that you say were made by the SCA had not been made, do you accept that this would not be a constitutional matter?
Yes. You say if the errors had not been made. If
I want to be careful how to phrase that. I'm not saying errors were made. I'm saying
No, I accept
based on the applicant's argument.
Yeah, no, I accept that entirely.
Yes.
Then I agree entirely that our complaint about the judgment would not have been a constitutional complaint. And may I again illustrate it with reference to the minority judgment. We don't agree with the minority judgment. We would have liked to, if it were the judgment of the court, we would have liked to appeal against it because it made one finding with which we did not agree. But that wouldn't have been a constitutional appeal, and this court's jurisdiction would not have been engaged, because that would be a conventional complaint that the court got it wrong.
Now, I know you've referred to Rand Refinery, and you've referred to Tue Jongeselling. Is there authority closer to home that the applicant can rely on for a breach of Section 34?
No.
Related to the facts of this matter?
No, except for the decisions to which we've referred that says that it is unconstitutional for a court to be unaware or to ignore evidence before it. And we submit with respect that whether the affidavit is not in the judge's file, or it is in the judge's file but the judge ignores it, is, constitutionally speaking, the same flaw. And in this case, it wasn't a case in which there was one affidavit absent from the record. It was a case in which the majority judges gave a judgment which they could not have given if they were aware of the issues and the evidence before them.
Isn't it simply that that is the way the majority judges saw the case? That is the way they saw what the issues were to be decided.
with respect-
And if they were wrong on that, how is that a failure of justice?
No, one sees nowhere in the majority judgment what they thought the case was. They contradict themselves and make statements without any foundation. But nobody can conceivably suggest that they had a different understanding of the issues. The heads of argument of the parties were before the court. They read much this, you'll see these debates on quantum. They were before the court. And for the court then not to recognize any of those issues and instead to say that Vodacom's counsel conceded the case, conceded that the award was not reasonable. There was just no basis on which the court could have rationally thought that to be so.
Let me move to another subject, Mr. Trengrove. Is the order that this court made in 2016 in this matter, is the interpretation or the meaning of that order in any way in dispute between the parties?
Yes.
And would this court then be required to give an interpretation or meaning to that order?
Yes, with respect, it's an issue addressed in our heads of argument and in that of our learned friends. We address it from page 3, from paragraph 8, through to paragraph 15. And the debate is this. I just didn't address it in my oral submissions because it is fully addressed in the heads of argument. And the only debate is this. The order that this court made is quoted on page 3 in paragraph 8 of our heads. The relevant part is part B. Vodacom is ordered to commence negotiations in good faith with Mr. Kenneth Makate for determining a reasonable compensation payable to him in terms of the agreement. And then C, in the event of the parties failing to agree on the reasonable compensation, the matter must be submitted to Vodacom's Chief Executive Officer for determination of the amount. The debate between us is this. We submit that on a proper interpretation of the court's order, the CEO's mandate was merely to determine an amount of reasonable compensation. That was his mandate. Our learned friends draw on other bits and pieces in the judgment in which they say the court must be understood to have said that that compensation must be a percentage of the revenue earned from PCM. That is the debate between us. But I won't re-argue it, but that is the debate. So there is a debate as to whether the court's order merely required the CEO to determine reasonable compensation, an amount of compensation, or whether it required him to determine the percentage of PCM revenue to be awarded to Mr. Makate.
If Mr. Makate is right, that the order that this court made in 2016 must be interpreted having regard to the content of the judgment, and it's not just reasonable compensation, but reasonable compensation with regard to a percentage of the revenue of PCM, would this court be entitled to make such a finding?
Let me say, of course, the court's order must be interpreted in the context of the judgment as a whole. You mustn't understand us to suggest differently. So on that principle, there is no difference between us and our learned friends. The difference arises merely on the outcome of that process of interpretation. But with respect, it doesn't take the case very far, because even if you interpret this court to have said that Mr. Makate must get a percentage of incremental revenue earned by PCM, that is what it got. It didn't say that that percentage must be paid to him for as long as PCM might earn revenue. It said a determination must be made in 2001 of fair compensation, and whether that compensation is calculated as a percentage of revenue or simply as a lump sum is neither here nor there, because the CEO did award him a percentage of incremental revenue over 5 years. And that is not inconsistent with anybody's interpretation of the mandate.
If the applicant was of the view that the order made by the majority of the SCA was vague, wasn't an avenue open to the applicant to approach that court? I think you may have referred to this already in your submission.
Sorry, Justice Tom.
So I think the point that I want to discuss with you, you may have referred to already in your submissions, and forgive me if we're repeating ground that has been traversed. I want to take you to paragraph 19 of the SCA judgment, which is in volume 25 at page 2599. And it deals with the omission of the MTR and the revenue from the PCM in relation to contract subscribers. Where it says...
Sorry, I've
Yes.
just mislaid my hard copy. Let me just find it here. Paragraph?
Paragraph 19 of the SCA judgment, towards the end of that paragraph, before this court, the least that counsel for Vodacom could do in this regard was to concede the error. He, however, submitted that the error was not relevant to the determination.
No, with respect, I didn't concede any errors whatsoever. The court was mistaken on that score. It's a little item, but that was just not so.
Now, we don't have a record or a transcript of the argument before the SCA. What must this court do with that? With what is in paragraph 19 and the arguments you've advanced today in respect of that paragraph?
What you could do is to ask my learned friends whether there was such an exchange. If they differ from me, I'll have to think about it. But if both sides tell you that there was no such concession made, then there's no reason why you shouldn't accept it. I don't even think those hearings are recorded, so I don't think there is a transcript of it.
Why is the standard of review and the Becker test before us, before this court?
Because for two reasons. The one is to interrogate the majority judgment to see, to identify the flaws in the majority judgment in its application of that test. That's the one. But then the second is, remember, we ask not only for the majority judgment to be overturned, we also ask you for a hearing on the merits of the review. And in both legs, the Becker test would be central to the inquiry.
So if this court was to grant Vodacom the relief that it seeks in giving it a rehearing, basically then all the issues that were before the SCA, factual, non-factual, standard of review, Becker test, all that then becomes issues for this court to determine.
Yes, and that is why both sides address all of those issues in their heads of argument. But that is also why we have said to you that whilst we would prefer to have a fair hearing of our appeal, a final hearing here and now, if this court decides otherwise, then the alternative would be to refer it back to the SCA. So we're catering for the possibility in the hope that you would finally determine the case. But if you decide otherwise, then there is another option of sending it back to the SCA.
Thank you, Mr. Trengrove. Thank you, Chief Justice.
Strong.
Okay, may I, Mr. Trengrove, and just to say that it will become more audible if you switch off your microphone when I speak, then you'll hear me better. Just let's try that. Yeah, that's the trick. Just to correct, before I get to my questions, just to correct something that you submitted, and I think it's a bona fide error. You referred us to paragraph 28 of Mr. Makate's submissions. 28. Now you said that there was you indicated that there was there was a mistake in that submission because footnote 29 refers to paragraph 8 of volume 25, page 2566. Because your point was that paragraph 8 doesn't say what it says, but it's just a mistake they made in their submissions. If you look at paragraph 7 of the judgment, of the application for leave to appeal, at page 2566, I think it's important that we correct this. Look at page 2566. You see, you read the part there at paragraph 8 because it's unconstitutional because they fell beyond its jurisdiction, blah, 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 blah. But just look above that. So what had happened is in that footnote, they'd made a mistake. They should have said paragraph 7, not paragraph 8. And if you look at paragraph 7, it's exactly what it says. Do you see that? It says, your complaint is that it seems to be a product of the majority's ignorance or disregard of the issues and evidence before the court. This feature of their judgment was also in breach of the rule of law and Vodacom's right to a fair hearing. So the point they make is your main complaint is that, and they refer to the wrong paragraph. Do you accept that? Then now you must switch on and I'll switch off.
I may well have made a mistake, but I've not been able to identify the place you say they relied on. Paragraph 7 has a number of subparagraphs.
I'm looking at page 2566. It starts at 2565 and then 2566 at the top. Sorry, I should have said 2566 at the top. And it's the second last sentence. They seem to be a product of the majority's ignorance or disregard of the issues and evidence before the court. This feature of their judgment was also in breach of the rule of law and Vodacom's right to a fair hearing. The point I'm making is all they're saying is that appears to be your main complaint.
I see it, and I thought that they had quoted verbatim from paragraph 8. But
No,
if
they
I'm
did not.
mistaken, then they didn't, but it was then corrected, or it was controverted in paragraph 8, because paragraph 8 says exactly the opposite.
Well, that's another point. I'm just pointing this out to you. Can I just say that when one starts at the beginning, what was before the High Court was an application for a review. And that was an application brought by Mr. Makate to review the CEO's decision. Now, and there, one of the central questions was what was Mr. Jusup's status as CEO? Was he a valuer? Was he an arbitrator? And so on. And then when it went to the SCA, what was before the SCA was an appeal against a dismissal of the review, an appeal for the dismissal of the review. In other words, you were the appellant. Now, if one looks at that, and assuming for the moment, because speaking for myself, I think prima facie, and I'll ask Mr. Michał about this, I think prima facie, if an apex court makes an order which is clear and unambiguous, that you must determine, you must negotiate in good faith, come to an agreement, and if you don't, there's a deadlock breaking mechanism, the CEO must determine compensation. If that is the clear and ambiguous terms of a court's order, and an inferior court, and I say that with respect, a lower court then attaches another interpretation which expands that order to beyond what that clear and ambiguous terms say, I think it must axiomatically close this court with jurisdiction. But that's something for Mr. Michał to consider when I talk to him about jurisdiction. But assuming the court has jurisdiction, and assuming that we are with you on the fact that, as you say, you didn't have a hearing in the proper sense as the Constitution meant a hearing to be, where a court does not, A, identify the issues correctly, B, identify the evidence relevant to those issues, and then decide the issues in the full conspectus of that evidence. Let's say we are with you there. I am hesitant to say that this court must then delve into very complicated merits, which includes a number of factual disputes. And it seems to me to be only in exceptional cases, as was the case in Trencon in this court, that you would decide the matter yourself. And it seems to me prima facie that you should remit. But I have two legs to the question. Why remit to the SCA and not all the way to the High Court? Can you explain to me that, why you say the remittal should be to the SCA and not to the High Court?
Let me say two things. Firstly, whether this court should decide the merits of the review, of the appeal, or remit to the SCA. On that score, we can't submit that there is a guiding requirement that requires you to decide the issue. We merely ask you, for the benefit of both sides, to do so to bring finality to the case. But we understand that there may well be a variety of reasons why this court may be reluctant to embark on what is a big nuts and bolts adjudication, and that it, for that reason, would decline to determine the appeal and refer it back. The second question then is back to where? Well, the case made before you is not that we had an unconstitutional hearing in the High Court. The case before you is that we had an unconstitutional appeal. We were entitled to a constitutional appeal and we didn't have it. So that the remedy should be one directed at that complaint by affording us a constitutionally compliant appeal. And that seems to be one by the SCA.
Now, bearing in mind what I said, if you look at the merits, there are two major complaints that Mr. Makate leveled against Vodacom on the merits. Vodacom says, Mr. Makate says Vodacom is introducing new evidence without having applied to do so, and it makes that assertion based on the expansive averments, they say, in Mr. Joseph's explanatory affidavit. And the second challenge that they make is they say two things, and the one you've dealt with, I think, adequately in my view. They say that if you abide a court's decision, you can't raise disputes of fact. Well, I'm not asking you about that. I'm satisfied with what you've said in your replying submissions. But they do say that where Vodacom say, and they talk about omnibus denials. They say there are a lot of omnibus bare denials, and then Vodacom then says, well, presumably Mr. Joseph will deal with it in the affidavit. Mr. Joseph then does not deal with it. And they say you've left a lot of the allegations unanswered. Now, I know that's a very global, general, broad question, but just the principle of those two submissions that they make.
Let me say that Mr. Joseph's firstly gave reasons for his award. Mr. Makate placed those reasons before the court because that was the determination of the amount under review. Mr. Joseph then filed an affidavit, an explanatory affidavit, as the decision maker called upon under Rule 53 to give such reasons for his award as he might think fit. So he filed that affidavit in his capacity as the decision maker. And there was no objection to it at the time. And we submit with respect, there is no room for any proper objection. It is legitimate for the decision maker, whose decision is taken on review under Rule 53, to supplement his original reasons, because he is now being challenged and not merely called upon to explain why he got to the numbers he did. So we submit with respect that it was an entirely legitimate affidavit for him to file. It was also not filed late. It was filed at the time, and they had ample opportunity to address it and deal with it. There's another point. It's an admin law point, where they say a decision maker is bound by the reasons given for the decision at the time and is not allowed to advance further reasons ex post facto. And that, they say, that is their complaint against the affidavit. But with the greatest of respect, two things. Firstly, Mr. Joseph's decision was not an administrative decision taken in the exercise of public power. It was a contractual power which he exercised by virtue of the party's consent. The same rules of admin law do not apply. And when you ask yourself under the Becker test whether the decision maker, Mr. Jusuf, whether he exercised the judgment of a reasonable person, that is an objective test. And there's no reason why Mr. Jusuf should not respond to the attacks on his decision by explaining, no, it's not that I didn't do this, I didn't do that, this is how I came about it. That's a debate about the question whether he exercised the judgment of a reasonable person. So we submit with respect not only that the affidavit is technically admissible, but also that that evidence that was merely an explanation of his actual reasons at the time, but even if he went further, that there is no rule comparable to the admin law rule that he may not respond to attacks on him by amplifying and justifying his award.
Yes, thank you. Last question from me, and it goes back a little. Well, it doesn't go back, it actually goes forward to a remedy. If a litigant gets an order which appears to be wrong, I'm not saying this is a patent error or not in this instance. I'm talking about the majority order, the SCA order. But if a litigant gets an order that says, for example, you're entitled to compensation of 5 to 7% of revenue, incremental revenue generated, and you're entitled to more interest or Section 25A interest, which is contradictory. And the litigant then says, I'm abandoning the 7%, I will rest with 5%. I'm abandoning the other interest, I will rest with more interest. Why does that not cure vagueness or unintelligibility that you rely on? I'm not sure if there's authority on that point. I can't seem to think that you cited any, and in my limited knowledge, I'm not aware of any. So I just want to clarify that, please.
Justice Majid, we are not aware of authority in point. And let me say this, that if the complaint had merely been that the judge said 5 to 7%, which is vague, but the rest of the judgment makes it clear that it should have been 5%, then I have no doubt that that error can be cured by proper interpretation. It might even be capable of cure by waiver of the upper percentage. But what our submission is more fundamental. Our submission is that the vagueness complaint is a complaint not only because of its vagueness, but is a further symptom of the court's failure to apply its mind to the determination of the case. And certainly for a court to cut and paste a notice of motion is a flaw so fundamental as to go far beyond the clerical errors in the text.
I think your fundamental complaint is that there was no cross-appeal. Yeah. Thank you, Mr. Tango. Thank you, CJ.
Mr. Trenkov, can I just take you back right from the beginning in 2016 when this court made an order about the fair and reasonable compensation? There seems to be that there are two contrasting views. The one of a fair and reasonable compensation, the other one advanced by Mr. Makate that he be entitled to 5% of the PCM revenue. If I had a look at our court order, the court order of our predecessors, it's silent on the 5% PCM revenue. I'm mindful of the fact that you read the court order in the light of the judgment. Would it be correct to assert that if this court in 2016 had intended that Mr. Makate be compensated by 5% of PCM revenue, that order would have been in the order itself?
Justice Matope, we submit with respect that that would have been so. Not only because it would have been more accurate, but it would have very significantly narrowed the CEO's discretion if the court were to prescribe to him that it should be 5% of PCM revenue. So that if that was its intention, then it was certainly inexplicable that it was not said in the order.
But then again, if the parties alive to that possibility decided to approach the High Court with that looming difficulty or hurdle, what was at the back of the party's mind, or what did they intend to achieve? Because, right or wrong, that would have attracted some contestation.
No, that is absolutely so. But that was, let me say in defense of Mr. Makate, firstly, that he did apply to this court subsequently for an order specifying that he was entitled to 5%, and the court dismissed that application. So I'm not suggesting that he could and should have done something of that kind. But Mr. Makate chose to come to review on paper, whilst it was obvious that there was a wide range of disputes. The first one being about the CEO's mandate, but then a myriad of other disputes on the actual quantification.
But then if that is the case, if one were to look at the principles that are enunciated in plus connivance, one has to look at the conduct of the parties at that time when they went to the High Court, because these disputes of fact were looming, and parties decided or elected to proceed nonetheless. Well, you are the respondent, you were the respondent in the High Court. There was no application for the leading of oral evidence by the other side.
With respect, Justice Matope, you're quite right. But the responsibility to do so lies with the applicant, not the respondent. It is for the applicant to decide whether to proceed by way of application or by action. If he decides to go by way of application, then he takes his chances, because he knows he will either have to make a case on the undisputed facts, or he will have to persuade the court to refer to oral evidence. But that is his responsibility. The respondent is entitled to say, there are disputes of fact, Plascon Evans knocks them out, you must fail in your application. That's what we did. It's not the respondent's responsibility to seek a solution to that problem.
But if you read the judgments of the two courts, the High Court and the two judgments of the SCA, one is left with a distinct impression that the product of what we are debating about now is because of those dispute of facts which they tried to resolve and which they could not resolve.
No,
there was
absolutely.
basically no evidence before the two courts to make a proper determination on the basis of what Mr. Makate was advancing.
You're absolutely right. And we submit that both courts erred on that score because they failed to apply the Plascon-Evans rule as they should have done. Plascon-Evans rule was ultimately correctly applied by the minority in the SCA. But that is what the High Court ought to have done in the first place. And what Vodacom did persistently is to complain that the fundamentals of Mr. Makate's contentions are based on disputes of fact. It raised that complaint again and again and again. Mr. Makate chose to take his chances to persuade a court to find in his favor despite those disputes. But that was a decision that was his. We submit he wrongly made.
Well, speaking for myself, back in the days when I used to sit at the High Court, confronted with an application of this nature, the question that I would ask myself is whether I would be able to make a fair determination on the issues. And if I could not, then I would have invited counsel to the possibility either of applying for oral evidence or going to trial?
No, that is so, and that is what judges often do. But it is not their responsibility, it's the responsibility of the litigant, and the responsibility in particular of the applicant who is faced with complaints of disputes of fact and decides to take his chances. That's what Mr. Makate did.
Well, I'm asking you these questions against the backdrop of your submissions that if we are with you, we should remit to the SCA. But if we remit to the SCA would be faced with the same problems that I have identified that you've confirmed that you have.
No, exactly. We submit that the disputes of fact are fatal to most of the quantum debate. But, and we're not suggesting that there is an easy answer. The SCA will be faced with it. But at least we are entitled to a judicial hearing and determination on the question whether we are right when we say the underlying facts are fatally in dispute, or whether Mr. Makate is right when he says that the disputes of fact should be ignored because his evidence is compelling. And you'll hear him today, you'll read his heads of argument. He ignores disputes of fact because he seeks to persuade you that his evidence is compelling and should for that reason be accepted. But that is not a permissible debate under the Plascon-Evans rule.
You've heard my concerns. Let's talk about jurisdiction, which my colleagues have raised with you. Is it correct to say the complaint of Vodacom is that it got a bad judgment or an imperfect judgment? Or the SCA strayed from the issues? And if a court stray from the delineated issues, does that engage the jurisdiction of this court?
No, certainly not. That is commonplace and everyday, and we won't suggest that raises a constitutional issue. But remember, we have really, I suppose, two categories of complaint. The first is the one that I've been hammering on, and that is that we didn't get a constitutionally compliant hearing. The court didn't identify the issues, identify the evidence, or determine the issues. That's the first fundamental complaint. But the other one about jurisdiction also says that when you appeal against a judgment given in favor of your opponent, then the Court of Appeal is enjoined to the determination of that appeal. And it does not have the power to then substitute the High Court's order for an order far more adverse to the applicant, namely an order in the terms of the notice of motion of Mr. Makate. So, but that's a further complaint. The fundamental underlying complaint is we haven't had a constitutional hearing. The added complaint is the court simply didn't have the power to do what it did. But it too was perhaps a symptom of the underlying failure to apply its mind to the case.
If the judgment, assuming we are against you, if the judgment of the SCA were to be left undisturbed, what message would that judgment be sending in light of what you have submitted, your 7 points? Assuming we say you have no jurisdiction, and if you have no jurisdiction, you're out, right? And then we must implement the judgment of the SCA. You would recall that there is a figure that has been bandied by the SCA, 5% to 7%. I don't know what figure can we say we have to agree to, because it's between 5 and 7%. What is the actual figure?
It depends on your interpretation of the order, but the figure needn't be calculated. If you look at the attachments to, or the addenda to the Mr. Makate's notice of motion, then you will see that he attaches various permutations of his order, and they yield numbers ranging from, I think it's 9 billion to 63 billion rands, depending on the permutations that you employ. So the answer is it doesn't require a calculation. What it does require is an identification of the particular permutation which is ultimately implemented.
Well, finally, assuming we are with Mr. Makate, are we in as good a position? Perhaps let me remove the first part. Are we in as good a position to make a determination as to what is a reasonable and fair compensation in the circumstance of this case? Can we make that assessment?
As good as who? Because you are in as good a position as the SCA, but you're not in as good a position as the CEO. He was appointed for his special knowledge, experience, and expertise, and the court certainly does not have those qualities. So that's why the prima facie remedy, if there is a fundamental flaw in his determination, is to refer it back to him. And let me say, that is also why he has behaved in this case as he does. He has been scrupulous in seeking to remain out of the fray, out of the combat in the court. He filed an explanatory affidavit without putting up an argument. He was represented in the High Court. His counsel was present in the SCA, but merely to be of assistance to the court. So he has kept himself in a position to make a redetermination if the court should so direct.
Should the fact that this litigation has gone on for many years, 18 years appropriately, weigh, do anything actually to weigh in our determination of the issues, or we shouldn't? It's a long time. At some point, finally, it has to be reached. But do we have the facts that can make us make a determination as to this is what has to be a fair and proper compensation? I'm asking you this
would you
because...
mind answering that question after the tea adjournment, Council? Oh, I'm sorry, you had not finished.
No, but we'll take that.
Okay. Tea adjournment until 11:30.
Thank you.
Got it?